In today's China, a smartphone can open a door, pay for food, book a doctor, enter a train station, and prove a person's health status. Digital technology has made life faster, easier, and more connected. China is now one of the largest digital societies in the world. By June 2025, China had more than 1.12 billion internet users, and mobile internet had become the main way people access digital services. Digital systems are no longer optional tools. They have become part of communication, payment, healthcare, transportation, public administration, and social participation. But behind this convenience, one important question appears. Are human rights fully protected in the digital world? When public services become digital, access is no longer only about physical distance. And when digital systems control movement, technology becomes directly connected to freedom, equality, and remedy. In the digital age, convenience often comes first, but human rights must not come last.
The first human rights concern is privacy. The first case is the Hangzhou Safari Park facial recognition case. In 2019, Guo Bing, a law professor, bought an annual membership card at Hangzhou Safari Park. At first, the park used fingerprint verification. Later, the park changed the system and required him to provide facial information to continue using the service. Guo Bing objected. He argued that facial information was sensitive personal information and should not be collected without a clear and necessary reason. The court later ruled partly in his favor. It recognized that facial information deserved stronger legal protection and ordered the deletion of his biometric information. This case is important because facial data is not ordinary data. A password can be changed and an identity card can be replaced, but a face is part of a person's permanent identity. This shows that digital convenience cannot justify unnecessary collection of sensitive personal information. But privacy risks are not limited to one facial recognition system. They also appear in the mobile applications people use every day. In China, mobile apps are used for shopping, transport, food delivery, banking, healthcare, education, and communication. However, some apps collect more personal information than necessary. They may request access to location data, contact lists, photos, microphones, device identifiers, or other information not directly needed for their basic functions. Users often click Agree without fully understanding what data is collected, how it is used, or whether it will be shared. China has introduced laws such as the Personal Information Protection Law, the Cybersecurity Law, and the Data Security Law. Regulators have also carried out privacy rectification campaigns against non-compliant apps. These two cases show that privacy protection requires necessity, transparency, meaningful consent, and strong enforcement. Digital technology may make services more convenient, but convenience should never become an excuse for excessive data collection. However, digital rights are not only about how data is collected, they are also about who can access digital services. During the COVID-19 pandemic, health QR codes became widely used in China. In many places, people needed to show a green health code before entering hospitals, public transport, residential communities, shopping centers, and public offices. For many people, this system was convenient, but for some elderly citizens, it became a barrier. Some elderly people did not own smartphones. Some did not know how to use health code applications. Others depended on family members for digital services. As a result, they could face difficulties when trying to travel, receive medical treatment, or enter public places. This is called digital exclusion. The system did not directly say that elderly people were excluded, but when essential services depended heavily on smartphones and QR codes, people without digital skills could be indirectly left behind. In response, China issued policy measures requiring alternatives such as identity card registration, paper certificates, and special channels for elderly people without health codes. This case shows that digital governance must be inclusive. Technology should improve access to services, not become a new barrier.
While elderly citizens may be unintentionally excluded by digital systems, the next case highlights a more serious concern. What happens when a digital governance tool is used beyond its original purpose? In 2022, some depositors of rural banks in Henan had difficulty withdrawing their savings. During this period, some reported that their COVID-19 health codes suddenly turned red. Under China's health code system, a red code could restrict movement and access to public services. Reuters reported that some depositors claimed their health codes changed when they planned to protest the blocked withdrawals. Reuters also noted that it could not independently confirm whether the code changes were intended to prevent the protests. Later, authorities investigated the incident. According to China Daily, officials were punished after health codes for 1,317 depositors were found to have been changed for non-epidemic reasons. This case is important because health codes were originally designed for public health, not for financial disputes or social control. It raises key legal questions about purpose limitation, legality, accountability, and freedom of movement. These issues will be examined further in the next section on legal analysis.
The Henan Red Health Code incident brings this documentary to a legal turning point. The issue is no longer only about one face scan, one mobile app, one health code, or one group of depositors. Together, these cases raise a bigger question. When digital systems collect data, control access to services, or affect movement, which human rights are involved? And what legal limits should control digital technology? This is why digital rights are not only a technology issue, they are a legal and human rights issue. Under the Universal Declaration of Human Rights, these cases involve several rights. Article 12 protects privacy, especially in facial recognition and excessive app data collection. Articles 1, 2, and 7 protect dignity, equality, and non-discrimination when digital systems exclude vulnerable groups. Article 13 protects freedom of movement when a health code affects travel or access to public places. Article 8 protects the right to an effective remedy, meaning people must be able to challenge digital decisions and seek accountability. From China's legal perspective, digital rights protection is supported by the Constitution, the Personal Information Protection Law, the Civil Code, the Cybersecurity Law, the Data Security Law, and laws protecting elderly citizens. These laws show that digital systems must be legal, necessary, proportionate, and used only for their proper purpose. They also require meaningful consent, accessible public services, accountability, and effective remedies when rights are affected. Therefore, the issue is not whether digital technology should be used, but whether it is used lawfully, proportionately, transparently, and inclusively.
The four cases show one common message. Digital technology should not only be efficient, it should also be lawful, fair, inclusive, and accountable. First, sensitive personal information such as facial data, health data, location data, and financial information should receive stronger protection. Organizations should not collect such data unless it is truly necessary and proportionate. Second, mobile applications and digital platforms should avoid excessive data collection. Privacy notices should be clear, and users should have real choices. Third, digital public services should include offline alternatives. Elderly people, rural residents, persons with disabilities, and low-income groups should not be excluded simply because they cannot use smartphones or online systems. Fourth, digital governance tools must be used only for their lawful purpose. A public health tool should not be used for unrelated purposes. If a digital system affects movement or access to services, there must be transparency, review, and appeal mechanisms. In conclusion, digital rights are human rights. Technology can support development, improve services, and make life more convenient. But it must be guided by human dignity, equality, privacy, accessibility, accountability, and the rule of law. The future of digital governance should be people-centered. Technology should serve human beings, not leave them behind. Digital technology should make life easier, but it should never make rights weaker.